I never can tell quite how long it takes to actually start the recording. So sometimes there's this like giant empty space, and sometimes I get recorded in mid 14th syllable. So anyway, here we are. And I am glad to be here with you tonight as we continue our exploration of racism in America, the history we didn't learn in school. Tonight, we're focusing on part 5, which is voter suppression then and now. As we have traced the chronological history of our country from its founding through the civil rights movement of the mid-20th century, we've seen repeated examples of concerted efforts to suppress the voting power of non-white people. Today, we will focus explicitly on the right to vote as the foundation of our democracy and the extraordinary efforts that have been expended and are intensifying to this day to prevent these citizens from achieving meaningful representation. So let's continue. We'll begin, as we do, with a brief recap of our program last week, where we focused significantly on the criminal justice system in the United States. And we didn't go back to the beginning of the United States, but rather looked at the events that occurred following the major decades of the civil rights movement that could have been viewed as a backlash against the progress made in terms of the rights of African Americans during that time period. And we began in 1970 with the war on drugs, begun by President Nixon, continued and amplified by President Reagan, and then by President Clinton. We saw that law enforcement incentives around the drug laws were put in place in order to redirect state and local law enforcement agencies toward the enforcement of these drug laws. We also saw the collateral impact of significant dollars being made available to law enforcement organizations and the resulting militarization of police forces in states and counties and cities across the country. We learned that in the context of mass incarceration, the United States leads the world. We are less than 5% of the world's population, and we imprison 25% of the world's prisoners. And in the course of all of this, there has been a disproportionate impact on people of color. And so we looked at the specifics, at the data, at the statistics, and see that our criminal justice system is in essence racialized at every stage, from initial stop to the possibility of appeal and to release. And so embedded in that is also actions that we might see as individual police violence. And we observed, based on some of the photographs from the civil rights movement, as well as the terror lynching history of our country, that very often the police forces, law enforcement, is the face of that discrimination against people of color. So today we're going to turn our attention to efforts to suppress the vote of those non-white in our country from the beginning to the present. We'll start with a historical framework of America's voting rights. We will then look at the path to representation for African Americans that followed the Civil War, and then, as a consequence, the adaptive tactics that were triggered by the white majority for nearly 100 years to try to continue to keep African Americans from voting. At the end of that 100 years, Congress passed the Voting Rights Act of 1965, which was momentous, but it didn't mark the end of the story. It simply triggered another set of adaptive tactics. And so we will look at the ongoing assault. In her book, White Rage, University of South Carolina professor Carol Anderson speaks about the reactions of the white power structure every time Black citizens, Black people make advances in terms of their rights. And so we see this played out significantly in our voting system. Any progress is met with a backlash. So we're going to start with the historical framework for voting in the United States. And the first mention, the first recording, is in the Declaration of Independence, where Thomas Jefferson wrote, "Governments are instituted among men." Yeah, the rest of us wouldn't have to wait a while. "Governments are instituted among men, deriving their just powers from the consent of the governed." And so our political system, our governmental system, is built on the fact that power of governmental officials come from the consent of those whom they are governing. And we'll see where that works and where it does not. We'll also look at the United States Constitution, what it has to say about voting, which in its original form says very little. And then we'll turn our attention to the constitutional amendments. In fact, the Constitution itself, in Article 1, Section 4, Clause 1, the only reference to voting, says the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But Congress may at any time make or alter such regulations, except as to the place of choosing senators. Kind of a strange clause. But in any case, it gives the right to set rules for voting to the states. But it is possible that Congress could override those state laws if it deemed it appropriate. So here are the constitutional amendments that deal with voting. And in fact, about a third of all the constitutional amendments after the Bill of Rights deal with voting in one form or another. So the first we learned when we looked at the end of the Civil War and the Reconstruction period was the 14th Amendment, ratified in 1868, that granted citizenship and due process to those who had formerly been enslaved. 2 years later, the 15th Amendment was ratified, and it declared that the right to vote could not be abridged or denied for reason of race, color, or previous condition of servitude. And so the thought had been, when the 14th Amendment was written and ratified, that that would, by giving citizenship to those formerly enslaved, sort of automatically give them the right to vote. But there was such an assault in 1868 on Black voters' rights that Congress felt compelled to pass the explicit 15th Amendment that said that right to vote would not be denied or abridged because of previous condition of servitude. And so things remained fairly static from that perspective for about 50 years until in 1920, the 19th Amendment was ratified that gave women the right to vote. But in practice, it only gave white women the right to vote. The reality is that Black women's rights in this regard did not occur until the passage of the Voting Rights Act in 1965. Continuing on, the 23rd Amendment enabled the citizens of the District of Columbia to be able to cast votes for president and vice president. The district has no representation in Congress, but they were given the right to vote for president by the 23rd Amendment in 1961. Finally, in 1964, poll taxes were outlawed, and we'll talk more about them in just a little bit. But they had been a major obstacle to poorer people in our country, and particularly poorer Black people in our country, to keeping them from being able to cast a vote. And then the last of the constitutional amendments that has dealt with voting so far is the 26th Amendment, which reduced the voting age from 21 to 18. And that was accomplished during the time of the Vietnam War, when there was a tremendous anti-war movement in general. But a piece of it was, if 18-year-olds can be drafted and sent to fight for their country and die, then they certainly are of an age that they should be allowed to vote for the people who are going to make those decisions. A very obscure law was passed in 1924, the Snyder Act, and it granted Native Americans the right to vote. They were here first, but this gave them the rights and responsibilities of citizenship. But from a federal perspective, and what we found is that the states continued to prohibit Native Americans from voting up until 1957, almost 30 years later. And then the last of the significant legislative pieces was the Voting Rights Act of 1965, which was passed to give teeth to and to enforce the 15th Amendment. It forbade literacy tests, and it established what was known as pre-clearance, federal oversight of state voting laws, and put in place federal examiners to make sure that the Voting Rights Act was being followed in the states. At that time, barely 50% of African Americans eligible to vote were actually registered. So we move back a bit to where this path began. The ability of African Americans, those formerly enslaved, to vote. We know in 1865, the 13th Amendment was ratified. In 1868, citizenship and due process were granted, and all of the states from the Confederacy who wanted to re-enter the Union had to ratify the 14th Amendment in order to be allowed to rejoin. And finally, the 15th Amendment in 1870, that ostensibly guaranteed African Americans the right to vote, that would provide representation at last. And the Black voting turnout in the first election after that amendment was ratified in 1870, the Black voting turnout was nearly 90%. And as a consequence, more than 600 state legislators who were elected were Black, 18 state executives. The governor of Louisiana was a Black man, and that's the last time that would happen until 1960. 18 U.S. congressmen were Black and 2 U.S. senators. And all of these African Americans elected to office worked collaboratively with their white counterparts to help craft laws on finance, on charitable and penal institutions, on public schools. And so this was part of the ray of hope of Reconstruction. But what we know is the adaptive tactics is in reaction to these advances began. And so violence as voter suppression took center stage. In 1865, the Ku Klux Klan was founded along with some other smaller organizations. In 1867, the Knights of the White Camellia were founded. These were 2 secret organizations. People wore hoods. They sought to keep their identity from at least some in the community. And yet, at the same time, there were others who knew full well who were members of the KKK and the Knights of the White Camellia. And moving onward, in 1874, the White League, and in 1875, the Red Shirts, were two terrorist organizations in opposition to Black rights were founded. And these were public organizations where everyone was clear about their intent and what they hoped to accomplish. And so we'll revisit the graphic that we saw from week 2 with an eye to the lynchings that were carried out specifically in order to disenfranchise Black citizens. Many of them were done for entertainment, for social transgressions, for minor law infractions, but a significant number of them were specifically designed to let Black people know what might happen to them if they tried to exercise their right to vote. And so in 1866 in New Orleans, white mobs attacked advocates that were marching for Black voting rights and killed 33 people. In 1868, there were an inordinate number of violent attacks. That was an election year. That was an important year. And in Camilla, Georgia, white mobs attacked Black residents who'd gathered to protest being disenfranchised and killed at least 7 people. In Opelousas, Louisiana, an estimated 200 Black people were killed over several days after trying to participate in the political process. In Caddo Parish, Louisiana, that year, at least 53 Black people are killed by white mobs wielding racial violence to suppress the Black vote. In St. Bernard Parish, New Orleans, that year, white mobs used violence to suppress the Black vote. In Bossier Parish, Louisiana, white mobs terrorized the entire Black community in widespread attacks leading up to Election Day, killing at least 162 Black people. And in McDuffie County, Georgia, that year, a Black man named Perry Jeffries, his wife, and 4 of their sons were attacked and lynched by white mobs that targeted Mr. Jeffries because he voted. And the stories went on and on and on, all aimed at making the message clear that, yes, at some level you had the right to vote, but it might not be worth giving up your life in order to try to accomplish that. And then, of course, with heightened violence around the time of the 1876 election, designed to try to keep as many Black voters as possible from the polls, there was no declared winner in the election between Samuel Tilden and Rutherford B. Hayes. And that was because 3 of the states, Republican states in the South, did not submit their electoral vote counts. And so a consortium of Supreme Court justices and congressmen came together and determined that they would name Rutherford B. Hayes president. They would award the disputed electoral votes to him, even though Samuel Tilden, based on the returns received, was only 1 short of being declared president. They would name Rutherford B. Hayes president if he promised to end Reconstruction. And he did, and they did. And the next stage played out on the national front. In 1890, the state of Mississippi convened a constitutional convention. And in writing this new constitution, they specified that in order to register, potential voters had to be Mississippi residents for 2 years. They had to pay an annual poll tax, but that poll tax was due from the first year that they were eligible to vote. So if a voter was 45, he had to pay the poll tax back from when he was 21.
That's weird.
They had to pass an elaborate literacy test that required an applicant to read and interpret a section of this new state constitution. As we said, we know that up through the end of the Civil War, in many states, it was against the law for African Americans to learn to read or write. And here we are 25 years later. Not only do you have to know how to read, you have to be able to read and interpret the Constitution. And it was a white poll worker who determined which section of the Constitution the prospective voter needed to read and interpret. So they would take a simple sentence, have a white person read it and interpret it. Election day will be held on the first Tuesday of November. That's the section of the Constitution you have to read and interpret. But the framers of this new Constitution specifically wrote into that document literally incomprehensible sections that made no sense. And those were the sections that were given to prospective Black voters that they had to read and interpret when there was no possible interpretation. James Vardaman was a Democrat who would go on to become the governor and then a United States senator from Mississippi. And he was one of the Constitution's framers. And I believe I quoted him to you in our second class. There is no use to equivocate or lie about the matter. Mississippi's Constitutional Convention of 1890 was held for no other purpose than to eliminate the N-word from politics. Let the world know it just as it is. They were in power. They got to make the rules. They didn't frankly care what the Constitution said, what the amendment said, that they could do that. And it's interesting that just today, there was an article in the newspaper that I read that was headlined, Mississippi Voters See Signs of Change. And in the context of this article were several other components of the 1890 Mississippi Constitution. One of them was that in order to win a statewide office in Mississippi, not only did you need to win the most votes, because today the Black population of Mississippi is 40% of the total for the state. So the 1890 Constitution said, in order to win a statewide office like governor or any one of a myriad of agency heads, not only did you have to win a majority of the votes, you had to win the votes in a majority of the districts in the state. The maps were drawn in such a way that that was impossible. So there have been no Black candidates elected to statewide offices in Mississippi up until today. Interestingly, Governor Tate Reeves, I believe, current governor, is facing a pretty solid challenge from a relative, Elvis Presley, who is running for governor from the Democratic Party. And in 2020, trying to think if it was there was a lawsuit, and that requirement of winning the majority of districts was repealed. And so now the election of a governor in Mississippi will be a function of who gets the most votes. Right. So it will be interesting to see what happens in that election. The other aspect of this Constitution was it had created a ton of new felonies that only applied to Black people. And if you were convicted of any of these, you would be forever disenfranchised. You would not be able to vote. And the circumstances are such that today, 1 in 10 Black voters in the state of Mississippi has a record. And so 10% of the Black population cannot cast a vote. And so there is work underway to try to get that particular law changed, but it hasn't moved as yet. So back to 1890, after Mississippi passed this constitution, every other Southern state followed suit.
Yeah, that's the way they all do.
Sorry?
Um, I'm sorry, I thought we were on mute, but I said that's the way all the Southern states do. They just follow whoever goes first.
Right.
Repress.
Right. Let me see if I can mute you. I don't think I can. Maybe you could mute yourself.
We can mute ourselves.
Okay, thank you.
Thank you. Sorry.
No problem. There was also a grandfather clause. Oops, sorry, I'm getting my screens old. There was a grandfather clause, and it said that if your grandfather had voted prior to 1867, and then any of your grandfather's descendants would be exempt from these laws. They'd be exempt from the poll tax, they'd be exempt from the literacy test, as long as your grandfather had voted before 1867. And no Black grandfathers had voted in that kind of time period. And so it let the prospective white voters slide through these new rules that only applied in essence to Black citizens. And so the impact on registration in Mississippi was, as I said, 90% of Black voters participated in the first election, and it dropped to less than 6% in 1892. Not to be outdone, Louisiana followed suit and held its own constitutional convention, again, specifically designed at disenfranchising African Americans to establish, quote, the supremacy of the white race. After its adoption that year, the number of registered Black voters dropped from more than 130,000 to 5,320. And by 1904, there were only 1,342 registered Black voters in the state of Louisiana. And seeing the success, all of the other Southern states followed suit, so that by 1910, no Southern Black people could vote, 0. And 30 years later, as efforts were made to try to extend enfranchisement to Black voters, by 1940, only 3% of Black residents were registered to vote. So what else could they do? Well, as it began to become clear that there might be some Black voters who could cast a vote, the parties determined that they would keep African Americans out of the political process. The Democratic Party in many states adopted a rule that barred them from party membership. So then they said, you can't vote in a primary if you're not a party member, but you can't be a party member. Finally, in 1921, the Supreme Court said, no, that's not right. You cannot keep them from being members of a political party. And so at that point in time, the accommodation was to say, we're going to take this back to the Supreme Court, where the court ruled in Newbery versus United States that political parties were private organizations and not part of the government election apparatus. And so, as private organizations, if they want to keep Black people from being members, keep anybody from being members, it's fine, because they're a private organization, not part of the political apparatus. Well, there was a subsequent decision, Smith v. Allwright, that said that's not appropriate, that's not constitutional. You have to allow Black people to be members of a party. So then Texas Democrats established a private association from which African Americans were excluded, and they held pre-primary elections to select the candidates. And then those candidates would go forward to the party to vote in the primaries, where now Black citizens could vote, but by then the determination had already been made as to who the candidates were going to be. And those pre-primary arrangements continued until 1953. While lynching was less an action of choice, intimidation continued in other ways. This is an editorial cartoon from the Miami Herald in 1940, just to make clear the history of the country and what it would mean to try to vote when really you shouldn't. There were other steps that were taken. As we learned from the period following the Civil War, many African Americans were employed in the sharecropper agricultural system, and that meant they didn't own their own land. They had a landlord who gave them space, and there was an arrangement made based on the crops that they were able to harvest and settle up financially. So as a consequence, an evicted sharecropper basically had nowhere else to go, because there weren't family members who owned property, there weren't friends who could take them in. And so in the midst of the civil rights movement in 1960, 1,400 African Americans registered to vote in Fayette County, Tennessee, and about 700 of them were evicted. White landowners in Greene County, Alabama, evicted at least 75 Black families that year, and more than 40 Black families were evicted in Lowndes County, Alabama, at Christmas time that year alone. Further, Black men and women who registered to vote were required to provide the names of their employers, who could then be notified that this Black employee of theirs had the audacity to register to vote. Newspapers printed the names of Black people who attempted to register, and white citizens' councils distributed voter lists to white merchants who denied basic necessities and employment to African Americans who registered or even tried to register to vote. In 1960, many evicted families were forced to live in tent cities that sprang up throughout the South. In communities that most closely resembled refugee camps, entire families sheltered in fabric tents that froze in the winter with no running water and one outhouse for dozens of people. Then white segregationist night riders terrorized the camps, firing guns into the tent cities in the middle of the night during the civil rights movement of the 50s and 60s. And so this resistance, this overwhelming resistance to the enforcement of the 15th Amendment, added additional fuel to the civil rights movement as activists tried to ensure that African Americans were able to exercise the rights of citizenship that they deserved. And so Congress passed the Voting Rights Act of 1965. It had three key elements. Section 2 language closely followed that of the 15th Amendment that said the right to vote cannot be denied or abridged on the basis of race, color, or condition of previous servitude. Section 4 established a formula for identifying jurisdictions across the country that had a history of racial discrimination. And it provided that Congress could update and rewrite that formula as time went on to determine which of these jurisdictions would be covered by the Voting Rights Act. Remember, the states were to write the laws, but Congress had the right to oversee the work that they were doing. And then Section 5 said that these targeted areas where this kind of voting discrimination ran rampant, they could not make any change to their voting laws without pre-clearance from the Department of Justice. Because what had been happening up till then was states just changed laws And if you didn't like them or you thought they were unfair, you had to file suit. It had to go through the courts. It had to go through the appeals process. The Voting Rights Act of 1965 said you cannot enact those laws unless you get pre-clearance from the Department of Justice. And this Voting Rights Act must be renewed by Congress every 5 years. So in 1970, Congress renewed the act for another 5 years. In 1975, they said, gosh, didn't we just do this? And they said, so, all right, we'll renew it for another 7 years. And then in 1982, when it came up before Congress again, Congress said, you know, this is silly. We'll renew it for 25 years. And they did. Then in 2006, when the time came to renew it again, Congress overwhelmingly reauthorized the law for another 25 years. And the vote was 390 to 33 in the House, and it was unanimous in the Senate. Imagine. And so what happened? Shelby County, Alabama, filed suit. Shelby v. Holder. In 2013, Eric Holder was the Attorney General of the United States. And the Supreme Court decision was to strike down Section 4 that released the 9 counties and 9 states and counties and municipalities. They were no longer subject to pre-clearance. They could make whatever voting laws they wished. And the rationale for the Supreme Court decision was, we don't have this problem anymore. Well, guess what? The reason that you don't have the problem is because you have the Voting Rights Act. So they gutted the Voting Rights Act. In less than 24 hours, the state of Texas instituted a law that the Department of Justice had previously blocked from being implemented. North Carolina reduced its early voting locations from 16 to 1. Alabama closed the DMV offices where people could get voter IDs in 8 of the 10 counties where the Black population was more than 75%. And so the assault began to ramp up. And it was based on the myth of voter fraud. And voter fraud is indeed a myth. There was a constitutional law scholar, Justin Levitt, at Loyola University, who did a study, and he looked at all of the votes cast between 2000 and 2014. There were 1 billion of them. I'm thinking Justin wasn't married. He probably didn't even have a girlfriend. I mean, 1 billion votes? Anyway, he reviewed 1 billion votes, and he determined that there were 36 cases where it's possible that voter ID fraud might have taken place. Didn't know that it did, but it was possible. 36 out of 1 billion. Nevertheless, it became the rallying cry for further voter suppression. And so states free of the Voting Rights Act began enacting voter ID laws. Before, I'm going to forget the year. Before 2000, there was not a state in the country that required a voter ID in order to vote. But the states began passing these laws. In the state of Alabama, everyone who lives in public housing is issued a government photo ID. You get that if you live in public housing, issued by the government. It does not qualify as a voter ID. You need a different voter ID. In the state of Georgia, they eliminated 12 types of IDs and substituted 6 government-issued photo IDs. In Atlanta's 2 counties that had a preponderance of Black residents, 64% of those without motor vehicles were African Americans. And yet you had to get your voter ID from the DMV. In the state of Indiana, there had not been a single instance of voter fraud in the state's entire history. So they passed a law that you had to have your birth certificate if you were going to get a driver's license or a state ID. But in Marion County, Indiana, home to more than 200,000 Black people, you had to have a driver's license as proof of ID to get your birth certificate. In North Carolina, Governor McCrory focused on fraud. The North Carolina Board of Elections analyzed 5 million votes in 2016 and found one case that a voter ID could have prevented. The legislature did a study to gather data on the IDs that Blacks did and did not have, and then they tailored the list of vote-worthy IDs to favor the ones that only whites held. When the Fourth Circuit Court was asked to review the law, their point was that this law targeted African Americans, quote, with almost surgical precision. In North Dakota, the Supreme Court determined that in order for your ID to be valid for voting, it had to have a street address. But Native Americans who live on reservations only have post office boxes. Their ID doesn't have a street address, and so it doesn't count if they were to try to vote. And in the state of Texas, I love this. A concealed carry permit is a valid photo ID to vote, but a student ID is not. In addition, states started purging voter rolls. Millions of voters have been purged from state voter rolls. There was a program called Crosscheck that was developed in the state of Kansas, and it looked at pairing names across the states that participated on the basis of first and last name and date of birth. You would be astonished at the number of people who have the same first and last name and date of birth. And so one year in the state of Iowa, the Crosscheck program flagged 240,000 Iowans and said they are also registered to vote in another state. And so Iowa embarked on an ambitious program to ferret out these criminals, these people trying to vote in 2 states. And when they were done with a taxpayer-funded study, they found that there were 6 people who were actually registered to vote in 2 states. In half the cases, they had moved from the other state to Iowa, and the other half they had moved from Iowa to the other state. And ultimately, the Crosscheck program fell out of favor because it cost a lot and it wasn't really accomplishing anything. But in the meantime, states kept purging voter rolls. Further, states began discriminating against predominantly minority precincts. They reduced the number of polling places. They limited the number of dates that you could cast a vote. And they also limited the number of resources that were applied and made available to minority precincts, which brings us to the vote in Florida in 2000. What happened leading up to the 2000 election was that state officials were horrified to discover that 16% of registered voters in Florida were Black, which was up from 10% in 1996. And that was likely to mean that they would vote for a Democrat. And so Florida election officials devised a laptop program that they let local election officials tap directly into the master database in Tallahassee, so that if someone showed up to vote, their name wasn't on the rolls there, they could tap into the database and say, oh yeah, yep, registered to vote. Well, in predominantly Black districts, only one of those got the laptop. The other precincts, they had to make a phone call to an election official in Tallahassee to have them look into the database to see if the individual was registered to vote. And as you can imagine, with one phone line to one agent in Tallahassee, not many calls went through. I think we also remember, those of us who were alive and paying attention at the time, about the hanging chads. Well, it turns out that most of the predominantly white districts had newfangled voting machines. The punch cards with the chads were also, were utilized in the predominantly Black precincts. Further, we know that intimidation was utilized. There were ballot integrity programs where Republican agents, sometimes aided by local police, would stand outside of polling places and, as Black people walked up to vote, would warn them that even an innocent technical error in their registration could mean that they could be subject to arrest. And in many instances, they also took their names and took photographs to make sure that the prospective voter felt suitably intimidated from casting his or her vote. Felon voting rights are a significant issue. The laws vary from state to state. In Maine and Vermont, you never lose your right to vote, ever. You can vote from prison. You can vote from jail. 14 states and the District of Columbia, you lose your right to vote while you're incarcerated, but immediately upon your release, your right to vote is restored. In 21 states, you lose your right to vote during incarceration, plus any probation or parole. Your right to vote is automatically restored, but you're not notified that that has happened. And you might have had a parole or probation period that lasted a decade or more, and you hadn't been able to vote during all that time, and it might never have occurred to you that your right to vote could be reinstated. And then 13 states, you lose your right to vote indefinitely. In one state, you have to be able to get a pardon for your crime from the governor. In another state, both houses of the legislature have to act on a law that specifically mentions you as an individual and restores your right to vote. And then there's an additional waiting period after that. You may recall that there was a referendum in Florida, I think it was in 2019 or early 2020, where the majority of Florida residents said, formerly incarcerated people should have their right to vote restored. And it ostensibly became law, except the state of Florida determined that, well, before you actually can go cast a vote, if you owe anything, any restitution, any fees, any fines, anything, all of those dollars must be paid before you can be granted the right to vote again. And I think we're all familiar with the acts of gerrymandering and the way districts are drawn to minimize the impact and effect of Black voters. So in addition to not providing fair representation, it creates safe districts where it makes no sense to even have an opponent, because there's no way a person of that other party could ever be elected. In a recent Wisconsin state election, Democrats got 52% of the votes. That translated to 39% of the seats. In North Carolina, Republicans got 50% of the vote, and it translated to 77% of the seats. And so the damage to the system and the belief in its equity continues to be damaged by these actions. And we know that after it, the Supreme Court decision in Citizens United has struck another blow toward the freedom of elections, with millions and millions or billions of dollars from corporations flooding into the political system. And just a little bit in terms of reaction to the 2020 elections, 49 states introduced 440 bills to restrict voting. 19 states enacted 34 laws that restricted vote by mail. Voter roll purges were amplified. Criminal charges were created if you aid a voter. There are states, as I think we all know, if you give a bottle of water to someone standing in line waiting to vote, that's a crime. In South Carolina, you cannot give anyone a ride to the polls unless they are a direct relative of yours. So if you have an elderly neighbor, somebody who needs some help, it is against the law for you to give them a ride to the polls. New voter ID requirements are being enacted, and proof of citizenship in some cases. It used to be if you could show an electric bill with your name and your address on it, that was good enough as a voter ID. But now there are states where you have to prove citizenship in order to vote. And one last statistic has to do with early and absentee voting. In the midst of COVID, clearly, that had an effect on the 2020 election. There were 158 million votes cast. 116 million of them were early or absentee, and 85 million of those were cast in the 33 states that are now proposing limits on early and absentee voting. And so the drumbeat continues. There is a lot of action underway in states. There's a nationwide organization, I believe, called Indivisibles, that is working to pass more equitable voting laws. Here in Delaware, the Delaware Voting Rights Coalition is doing a lot of work in that regard. The pressure is enormous to limit voting, but progress is being made small steps at a time to try to undo that damage and to try to expand the base of voters and to make sure that their voices are heard. But the power structure understands the nature of power and the nature of staying in power. And so it's clear that we, each of us individually, collectively, need to make our voices heard about these voting laws. It's the way the system works. As Thomas Jefferson said, the right to govern is granted by the consent of the governed. And so that's foundational to our principles. We just need to make it more real. So I will stop, see what comments, questions, experiences you would like to share. Rob?
I just wanted to say, tomorrow's election day, and it's an off-year election. Judges and school board members are the primary people that we're going to be voting for in Pennsylvania tomorrow. And the off-year elections are usually the least attended, the least votes that are cast. And they're probably as important as electing our national leaders. Yeah. Because how many congressmen, for instance, started out as a school board member? Mm-hmm. And they just kind of creep into the system, infiltrate the system, and then move up because they get name recognition and people vote for them later on, and we find them in Congress. The only way I can see to change all of this is through intelligent voting. To know who you're voting for, even at the lowest levels of political office. Otherwise, the whole system just gets corrupted. And these things with the voter suppression, for instance, just continues and grows. Mm-hmm. It's really pretty sad that we don't take our voting rights more seriously.
Well, and to your point about school board elections, I mean, I confess, I've always voted in school board elections, but I'd never been to a school board meeting until 2 years ago. And they are instructive. Mm-hmm. They are worth attending. They are worth paying attention to. And what we know is that some of these people who are starting their political careers on school boards can do inestimable damage even at the school board level. We are seeing that. We see that with band. We see that with not teaching Black history. We all across the board. And it's because it's been a concerted program to do that. It's not happenstance. It's not coincidence. It's an intentional plan to do this, and it's been very successful. And so just on the basis of that, it's so important to vote. And then if you're talking about judges, of course, I don't think judges should be elected anyway, but I don't know, it's the law. Although some judges who've been appointed aren't the best either. So I'm not sure what the perfect system is in all of that, but it matters who's elected as a judge. It matters. And I think for each of us to recognize that it's not just a case of, well, I'll wait, next year's a big election. So yep, I'll gear up for that one. We did see in the midterm elections, even on a national basis and a state basis, that it made a difference, that more people turned out to vote. It's the way we give our consent. It's the way our voice is heard. And so supporting programs and projects that encourage voting, that encourage information about voting. Some of the new laws that have been passed say you can change polling places, you can change rules. You don't ever have to tell the voters what you've done. And so when they show up to vote, if they're in the wrong place, if they don't have the right information, not your problem, it's theirs. But you have no obligation to tell them that you've made any changes. Those laws shouldn't be enacted.
All right.
Thank you. Well, we are at the end of our time. And I know some of this just seems so overwhelming. It's like the issues are everywhere. The problems are everywhere. They're so deeply ingrained in our system. Not going to be fixed in my lifetime, not going to be fixed in yours. But we have the capacity, we have the wherewithal to take baby steps, to make progress, to stop the worst of the abuses, and to bend the arc of the moral universe just a little bit more. And that is within each of our ability and power to do. And I think what I hope is that this history shows the importance of doing that, of taking action in whatever arena speaks to your heart. No one of us can throw ourselves into all of these issues. There simply isn't enough bandwidth, time, energy, whatever. But there's something really important to each of us, or a couple really important. And to devote our time and our energy there is the work to be done. And that's the focus of our class next week. Now that we know what we know, we should have known, but we didn't, and we see it, what are we going to do about it? So I look forward to seeing you next week.
Thank you.
Thank you,
Thank
Sue.
you, Sue.
Good night.
Thank you, Sue.